Okay, let me take this opportunity once again to greet you all and welcome you to this topic of today. First, my name is Scott. I am a law student, and the purpose of this recording is to teach you on the unit of equity and the law of trust. Equity is one of the unit in law. It's 1.2 unit. So let's begin. First, you need to ask yourself, what's equity? You know, and in simple terms, equity means fairness and justice in any particular thing that you do. The fairness and justice, that's equity. So this equity has some historical development behind this law of equity, and that takes us to some 121 1215 AD, and that was the beginning of common law. So the common law existed in the 16th century, but there was problem with this law. This law was, there were complaints that this law couldn't provide the judges, didn't have the, what are they called? Those discretionary powers. They did not have discretionary powers, and this common law was kind of biased. It was kind of biased, and that there was the need of coming up with a law of equity that could cater with the challenges that used to occur in the common law. We know common law is the law that is based on statutes, the parliamentary law. So, reason for the introduction of law of equity: number one, the common law was rigid, uncertain. Number two, the common law only recognized one remedy, which was damages. Number three, and we also know that there is no wrong suffered in equity without a remedy. So the only remedy in common law was damages, and that people needed, felt like their issues were not solved in the best way, because this common law was rigid. It only provided one remedy, which was damages, and common law recognized writ system. And let me explain what writ system is. Writ system is that scenario whereby, in common law cases, it's based on judicial precedent, whereby cases are decided by the court, and in the court, when judges make decision, they try to look on other cases or other courts, the superior courts, on what they decided on to come up with a decision. So it's called judicial precedents. We have several types of precedent, which I hope you, as a law student, you studied in the legal system unit. So this common law system recognized the writ system, and this writ system is whereby where there is no precedent or there is no other case decided in the no previous case in a particular issue, that case is dropped. And you can imagine the amount you have suffered. You have filed a plaint, it has costed you money, you haven't been compensated yet, and it's just scrapped off because there is no precedent. It sounds like there is no fairness at all, and that's the situation whereby we call miscarriage of justice. There's no justice at all, and you can imagine of such situation. So that brought that urge of coming up with a law of equity, a law that could, cut off all these challenges that used to occur in the common law. So the common law judges were not allowed to exercise discretionary powers, as I said earlier on. Discretionary powers, it is from this harshness of common law that the litigants petitioned to the king. The king, in his capacity, appointed Lord Chancellor to look into their grievances. In the 16th century, Lord Chancellor came up with a recommendation for the need to establish the law of equity. So Lord Chancellor, the king, during those earlier times, the Roman law, the common law existed, came from Rome, So they were used to be ruled by kings. So the king noted that there were challenges in this common law system. So he appointed Lord Chancellor. And Lord Chancellor, the purposes of appointing him was to go into this common law system, check what is this that is causing unrest. What is this that people are complaining about common law? So this Lord Chancellor was to come up with a recommendation on how to improve this common law or to come up with a law of equity. And these people who appointed the Lord Chancellor are people like priests, people who not legal professions, but they're just mainly most of them are priests. Yeah. So another reason we have looked at the discretionary power that judges are not allowed. The other reason for establishment of law of equity was basically to mitigate the harshness that was meted out by common law. Imagine that kind of harshness whereby there is no other the reed system, which is so harsh. It's so harsh such that it cannot stand at all. People will feel that cause miscarriage of justice. There will be no justice, and people will feel like they are not satisfied with these systems. So the other reason was to mitigate the harshness that used to exist in the common law system. So, okay, the law of equity ought to have been flexible in nature. It expressed flexibility of character. It was fluctuating like the chancellor's foot. The law of equity. Now they are describing this law of equity. It used to fluctuate, and that people are demanding it not to fluctuate. That was suited the law of equity being flexible, exercising their discretionary powers, equity. So as the chancellor worked, the law of equity worked. In the case of Guy versus Pritchard, Pritchard is Pritchard, Pritchard. It was said that it was as much as the law of equity should be certain and settled, it should not be able to lose its flexibility character. This case, they were demanding that this law of equity, they described it to be fluctuating as the chancellor's foot. The chancellors were people who made or came up with this law of equity. So in the case of Guy versus Pritchard, they were claiming that this law should be stable, should be flexible, shouldn't be, but not rigid. Please not. It shouldn't be fluctuating most of the time. It should just be flexible, such that people can trust in it. So you also have another case of Free D Block. And in the case of Free D Block, it was said that the chancery courts, that word is hard to pronounce. Chancery court must exercise equitable jurisdiction. Equitable jurisdiction by the chancery courts. The powers in this chancery court must be seen to be equal. The equality aspect, equitable jurisdiction. The powers must be of equitable jurisdiction. Okay. In the case of National Assurance Company, this is the third case. You must note these case notes, they are very important. In the case of National Assurance Company Limited, it was held that equity courts are not courts of conscience but courts of the law. It's not what the judges think, but they must be guided by the law. It's not the court of conscience. as opposed to the common law system, where judges were not allowed to exercise discretionary powers. And to come up with this law of equity, they're trying to tell these people that the court of equity are not court of conscience. It's not about what judges think or what they feel is good, but they must be guided by the law. And under maxims of equity, we shall note that equity follows the law. While judges make their decisions, they must be guided by the law. Where equities are equal, we shall look at the maxims of equity. The law prevails, and that brings that importance aspect of the law. The law is very, very important. And that's why they ruled in the case of Rain National Assurance Company Limited that it was said that equity courts are not courts of conscience, but courts of the law. I think you're understanding. We are getting it. So, they are courts of the law. They are not judgment courts. It's not about what judges think about particular issues. It's about what the law says. So equity must follow the law. In Earl of Oxford, in the case of Earl of Oxford, EARL, Earl of Oxford, where common law and the law of equity conflict, the law of equity prevails. This is just an improvement of common law. So, where there is a conflict between these two particular courts, the court of equity is more superior to the common law. That's the case of Earl of Oxford. Yeah. Two legal system of common law and the law of equity. The introduction of law of equity didn't extinguish the position of common law. I mean, the common law position was just there. It was not to extinguish it, but it was just to improve it, to cut or to fill the space, the gap, the void that existed in the common law. The two legal systems of common law and the law of equity complement each other. They just work to complement each other. But where they conflict, the law of equity must prevail because it's an improvement. So, there are certain circumstances where a case is adequately addressed by the common law. In that case, you do not need to invoke the law of equity. I mean, there are cases whereby the common law has just a ruled and there is no need of appealing. It has adequately been addressed, parties feel satisfied about the decisions. Then that they are saying there is no need at all to involve the law of equity. So, just to look at the common law courts. What are these common law courts? Common Law Procedure Act 1854 gave the common law courts limited power of granting injunction, something that was, the injunction, this is an order to stop a particular issue. The order from court is to stop a particular issue from being or from happening. That's an injunction. The Common Law Procedure Act of 1854 gave the common law courts limited power to granting injunctions. By Chancery Amendment Act of 1858, the Court of Chancery was given powers to award damages. This is to mitigate each other, awarding damages. And the High Court had 5 divisions. This is under the common law. The Queen's Bench, the Common Plea, the Chancery Court, and the Probate, Divorce, and Marriage Court. Please note those are 4, the 5, yeah. I said the Queen's Bench, the Common Plea, the Chancery Court, ex-charter courts, the Queen's Bench, Common Plea, ex-charter courts, Probate, Divorce, and Marriage Court. Yeah. Queen's Bench, Common Plea, ex-charter court, Chancery Courts, Probate, Divorce, and Marriage Court. Those are 5. So, those are divisions under the common law, the High Court divisions: Queen's Court, Common Pleas, Common Charter Courts, the Chancellor Court, and the Probate Marriage and Divorce Court. We know of what the High Court is. Now, under the High Court in our constitution here in Kenya has been given that mandate of dealing with issues to election, and it's the third largest court. So in the common law court, there was also the High Court, and the High Court under this High Court was divided into 5 divisions, as I have mentioned. So yeah. So we have categories of torts, but I'm not going to look at it. I'll look at on it later. Yeah, nominators and all other torts. So let us look at the natural justice. What is natural justice? We have rules of natural justice, and we have 2 rules of natural justice. The first rule is the rule of audi alteram partem, and the second rule is nemo judex in causa sua. The first rule is audi alteram partem. What does it say? This rule of audi alteram partem demands for a fair hearing, and the Constitution of Kenya provides under Article 50 right to fair hearing. And this rule of audi alteram partem demands that no person shall be condemned unheard. Nobody shall be condemned unheard. Before you are condemned, you must be heard. Fair hearing must be done. That's what it demands. Simple terms, that is just what it means. So the another rule is that nemo judex in causa sua. Nobody shall be a judge in his or her own case. Nemo judex in causa sua. Audi alteram partem, nemo judex in causa sua. You shall not be a judge in your own case. Good. Let me expound on it, what the book says. No man shall be a judge in his own case. The rule is also aimed at ensuring that there is no conflict of interest in adjudication of the matters. That conflict of interest. The sitting judge with the conflict of interest will recuse from the matter. Recuse is to me, this means that you will get out of the matter. If this is your judge, yes, and maybe one of your litigants or the lawyer to come before you was your law student, or maybe you schooled with him, or he or she in the same school, law school, and that he has come, maybe, okay, you feel this matter whereby you have some interest in it. Maybe it's a land and you have been associated with that particular case. As a judge, to ensure that you avoid conflicts of interest, you must recuse yourself from that issue, because when it will be noted later on that you are part of this, and that maybe the judgment that was made or ruled may be as a result of what you participated in the case, or participation in the case, then people will feel that there is miscarriage of justice. So it's as a judge, you must recuse yourself from that particular issue. So that's the issue of nemo judex in causa sua. You shall not be a judge in your own case. In your own case, please note this. You must do what you must recuse to avoid conflict of interest. So I just want to highlight the conflicts of interest. There are 4 of them. You have the plenary conflict of interest, proprietary conflict of interest, personal conflict of interest, and fiduciary conflict of interest. Proprietary conflict of interest is where the subject matter is the property, is the land. It's called proprietary conflict of interest. Personal conflict of interest is whereby there exists that personal relationship, your brother, your son, your father, your friend, your mother. Personal conflict of interest. Fiduciary conflict of interest is whereby there is trust and confidence to exist. It's called fiduciary conflict of interest. Good. So, we are going now to look at the maxims of equity. And before I look at them, you must know that there are many maxims of equity. I mean many. More than 20 maxims of equity. And we shall look at those that I have been able to capture. But just know that there are many maxims of equity. Others we shall just mention them even without explaining them. We shall also touch on the case laws under the maxims of equity. So, maxims of equity in simple terms, there are legal maxims that serve as a set of general principles of rules which are said to govern the way in which equity operates. They govern how the law of equity operates. So, they tend to illustrate how the qualities of equity in conflict, they tend to illustrate the qualities of equity in contrast to the common law as more flexible, responsive approach to the needs of individuals, inclined to take into account the parties' conduct and worthiness. They are developed from English courts of chancery and other courts that administer equity jurisdiction, including the law of trusts. Although the most fundamental and time herald of the maxims are listed in this page, the roles of maxims. What are the roles of maxims? Maxims of equity are not rigid. They are not rigid set of rules, but are rather general principle which can be derived from in specific cases. Before I look at them, know that they are not rigid, but they are rules, set of rules, general principle which can be derived from in specific cases. In litigating a case, derived from this, can derive from these maxims of equity. They do not cover the whole ground, and moreover, they overlap. One maxim contains by implication what belongs to another. Okay, one maxim contains by implication what belongs. Indeed, it would be difficult to reduce all under two. Equity will not suffer wrong. So, list of maxims. We have several of them. We have equity is equality. Equity, he who comes to equity must come with clean hands. Equity follows the law. Where two equities are equal, the law prevails. Where two equities are equal, the first in terms of time prevails. Equity shall not suffer wrong without a remedy. And equity acts in personam, not in property or in. Okay, equity looks at the intent rather than the form. Equity regards to as done what ought to be done. Equity follows the law. Equity abhors forfeiture. Delay defeats equity. He who comes, So let's start with equity is equality, and let me try go through them. Equity follows the law. So the Court of Chancery never claimed to override the course of common law. The common law just existed, as I have said earlier on, but this Court of Equality was just to complement this common law, but not to override it. Statute of law is direct and governs the case with all circumstances of a particular point. A court of equity is as much bound by it as a court of law and can, as illustrated, justify departure from it. Law of maxims forms the basis of the rules of on priority and can be constructed with the maxims whereby the equities are equal. The first one in terms of time prevail. So equity follows the law. As I said earlier on, the law is very important and equity must follow the law. So he who seeks equity must do equity. When you want to find justice in court, you must do justice. When you want something to, if you want to be respected, let's use it as an example, you must be ready to respect. Do to others what you want them to do unto you. He who seeks equity must do equity. The person who is seeking aid of court of equity must be prepared to follow court's directions, to abide by whatever condition the court gives. And with this, let's look at the case of Lodge versus National Union Investment Company Limited, 1907. This is a case which B had borrowed money from a money lender M and B mortgaged some security to M for the loan. It turned out that M was not registered money lender by law. The Money Lender Act of under the Money Lender Act of England, B sued M for delivering his security back to him, and here the court refused to grant the order unless B first repays the loan. Okay, today a court cannot enforce illegal action such as that. So this is a case whereby somebody went to borrow money from someone who had not registered under the English Lenders Money Act. So this person who had given out his money went demanding the money, but this person refused to give because this person, he claimed that the person had not been registered. But the court said that you must do equity, such that this person who had borrowed the money must first pay the money before claiming security. So it's simple as that. Another case, he who comes to equity must come with clean hands. The case of Gill versus Lois, tenants had used the premises for a purpose that was not allowed under the lease. He who comes to equity shall not have equity. He who committed inequality shall not have equity. So we also have the case of Jones versus Lethal, 1669. So let's take an example. These are robbers. They have gone to rob a particular bank, and maybe they disagree amongst themselves and maybe on how to share the money. So these people cannot go to court because the court demands that he who comes to equity must come with a clean hands. But the court will question, where do you get that money? Is it clean means? No. So it ends there. So in Longvan versus, okay, let's not look at that. Equity is equality, presumption of tenancy. Yeah, equity is equality. And what does it mean? Where two people are entitled to same property and there is no basis of division, those who entitled to property should have certain unfairness, equal division. Equity is in the sense that does not mean literally equal but proportionate equally. Equity is equality. It doesn't mean that it should be that equal, but the proportion that will make people feel the equitable justice, some kinds of justice. So equity is equality. whereby the court tries to assure that there is equality in things being done. Okay, equity looks at the substance or intent rather than the form. Equity looks at that intention. Intention. Did you have the intention, but not the form? The form. So, yeah. Equity will give priority to substance or intent as opposed to the form. There is a contradiction. This maxim is normally applied in trust. So equity regards as done that which ought to be done. In Walsh versus Lonsdale, agreement to lease good was as good as the agreement itself. Walsh versus Lonsdale, done what ought to have been done. You also have Souza Figuendo versus Moorings Hotel. The court held that an unregistered lease cannot create any interest, rights, or counter any estate which is invalid against a third party. However, it operates as a contract inter partes. It's valid between the parties and can be specifically enforced. The tenant in this case was therefore liable to pay rent in arrears. Equity regards than what ought to be done. Equity includes an intent to fulfill an obligation. Equity will not suffer a wrong without a remedy. There must be a remedy. Equity acts in personam, in person. Equity does not act in rem. Rem means property. Equity describes the procedure, not the writ issued to you. That's the case of Penn versus Baltimore. Court of Chancery dished out equity because common law used to be harsh and rigid. A personam against the defendant personally. So another one is equity will not assist a volunteer. And a volunteer, who is a volunteer? A volunteer is a person who cannot pay consideration. Just take an example. You have a friend, you want to inherit his property after his death, and you have never given him anything, paid something. So you never paid consideration. When it goes to court, you not inherit because you never paid consideration, because equity shall not award a volunteer. Yeah. So equity does not act in vain, and equity does not act in vain is another maxim. Delay defeats equity, and even the Constitution provides that for justice delayed, justice denied. Another maxim is equity will not perfect an imperfect gift. That under this we have the case of Milroy versus Lord. An imperfect gift equity will not perfect an imperfect gift. This is a case about the shares in the bank, and 50 shares. Thomas had 50 shares, Samuel did nothing to them. Equity regards the beneficiary as the true owner. Equity will not allow the statute to be used as a cloak of fraud. Statutes are law made in Parliament. So, between equal equities, the first one in order of time shall prevail. Equity does not require idle gesture. So next time you're going just to look at this maxim of equity. We shall expound on them because I just mentioned some of them. I have not explained the case law as well, but soon I'll post another video and explain well before touching on equitable remedies. So It has been a good class. I hope you will subscribe for more lessons. And um, just an advice to my listeners: success is not for the chosen few, but for the few who choose. That's according to Mr. Fad Miomba, our forced migration lecturer. So, just want to wish you a good day as lawyers keep on studying and reading. Read the case laws, the constitution, various statutes, and some case laws. So, have a nice day. Don't forget to subscribe. I am Scott. I wish you a good day. Sanitize.